today's online talk, which will be starting shortly. For those who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Drink Driving Offences in Malaysia. My name is Vivien and I'm an associate with Mabuk and Associates. I'll be a moderator for today's session. Before we start today's session, allow me to introduce the firm and what we do. Mabuk and Associates is a mid-sized law firm that was founded in 1985 by Datuk Mabuk. Our able team today comprises 22 lawyers and a support team of 19. Dato' Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We're a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which are also broadcasted live. But since the implementation of the COVID-19 Movement Control Order, or MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel, and we have continued this practice until RMCO now. This is the 23rd talk in our MWK online talk series, and today we're expecting about an estimate of 70 people who have registered online. Please feel free to visit our website at mawinkwai.com for more information on what each of our team does, our online products, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please feel free to contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, allow me to introduce our first speaker for today. Our first speaker is Ms. Janessa. She is an associate in our Dispute Resolution, Employment, and Individual and Families departments. She holds a Bachelor of Laws from the University of Liverpool, UK, and she was admitted to the High Court of Malaya in 2017. Janessa's practice areas include employment and industrial relations disputes, corporate and commercial litigation, and general litigation, particularly in family, criminal, debt recovery, and contractual disputes. Following Janessa is our next speaker, Mr. Cheong. Ryan is our pupil in chambers in our dispute resolution and construction departments. He graduated with a Bachelor of Laws from the University of Reading and was called to the Bar of England and Wales, Middle Temple, in 2019. Our speakers hope to complete today's talk by 3:45 and thereafter proceed with the Q&A question. If you have any questions, please don't forget to post them on Slido and we will address them later. You should have received a link to Slido during your registration for this talk, but I will leave this slide up for a while so that you can scan the QR code before we move on. Alternatively, you can go to Slido's webpage at the left-hand corner of my slide in front of you, at the left-hand corner at the bottom, and key in the code 18668. I repeat, 18668. Our talk today will cover the following points. For today's session, our first speaker, Janessa, will enlighten you on the offence of driving under the influence of alcohol and its penalties, your legal rights and obligations at a police roadblock, and the rights of an arrested person. Ryan will then take over to further discuss the police powers after arrest, a brief comparison between the drink driving penalties in Malaysia and a few other jurisdictions. He will also bring you to the recent discussions on stricter law and punishments. With that said, I will now pass the floor to Janessa. Over to you, Janessa.
Thank you, Vivien, for the introduction. Hi, everyone. Thank you for your interest and participation in our online talk, particularly for today's topic on drink driving. My colleague Ryan and I will talk about the key issues in relation to drink driving offences in Malaysia. I will kickstart my session with the introduction of the Road Transport Act 1987. Sections 45, 44, and 45A are the three main provisions under the Road Transport Act that I've plucked out for the purposes of today's discussion. For your easy reference and for comparison purposes, we can take a look at this slide here. The key difference here is that Section 44 of the Road Transport Act would apply in cases where someone is injured or in the event of death that is caused by an intoxicated driver. Let me zoom into Section 44 quickly. The provision here would apply in the event an individual is found to be driving under the influence of alcohol to an extent where he is incapable of having full or proper control of his vehicle. This provision would also apply in situations where the breath, urine, or blood test result shows that the alcohol percentage in the person's body exceeds the prescribed limit. Moving on to Section 45 of the Road Transport Act. The noteworthy point under this provision is the fact that an individual may be charged even if he is not driving the vehicle yet. So what do we mean by that? Under Section 45, for so long as you're in charge of the vehicle and you are found to be intoxicated and unfit to drive, it would also be an offence under the law. Let me give you two examples here. If you are found seated at the driver's seat and resting after having a couple of drinks at the bar, the police officer will have reasonable grounds to believe that you're in control or in charge of the vehicle. Another example would be if you're walking towards the car in a state of drunkenness and you are unable to walk properly. Subsequently, you unlock the car door and you're stopped by the police officer. The police officer will also have reasonable grounds to believe that you were in charge or you are in charge of or having control over the vehicle. These are the circumstances that would cause suspicion, and the police officer may have reasons to suspect that there is a potential risk of you driving in an intoxicated state. As for Section 45A of the Road Transport Act, this provision may apply in the event you are found to be driving or being in charge of the vehicle and the amount of alcohol in your body exceeds the prescribed limit. The point to be highlighted for this provision here is that an individual can still be charged for driving or attempting to drive under the influence of alcohol, even if it does not involve or cause injuries or deaths. Moving on, Section 45G of the Road Transport Act provides the statutory prescribed limit. So earlier I mentioned that it is an offence to drive or attempt to drive in the event the amount of alcohol in your body exceeds the prescribed limit. An individual, if suspected of driving or attempting to drive under the influence of alcohol, may be compelled to undergo a breath test, blood test, or urine test. In order for an individual to pass these tests, the amount of alcohol in his body shall not exceed the limits stated under Section 45G, which you can see in this slide before you. So what are the penalties? For Section 44 of the Road Transport Act, If an individual is charged under this provision and is subsequently found guilty, he will be sentenced to an imprisonment of 3 to 10 years and a fine between 8,000 ringgit to 10,000 ringgit. He will also be disqualified from holding a driving license for a period of not less than 5 years. However, this is only applicable for first conviction. If an individual is found guilty for a second or subsequent conviction, in other words, a repeated offence, his license will be disqualified for a period of 10 years. If an individual is charged under Section 45 of the Road Transport Act and is found guilty for the first time, he will be sentenced to a fine of up to 1,000 ringgit and an imprisonment of up to 3 months. If, however, he is found guilty for the second time or more, he will be sentenced to a fine between 2,000 ringgit to 6,000 ringgit and an imprisonment of up to 12 months. In addition to these two, he may also be disqualified from holding a driving license for a period of 12 months or more. If an individual is charged under Section 45A and is found guilty for the first time, he will be sentenced to a fine between 1,000 ringgit to 6,000 ringgit, as well as an imprisonment for a term not exceeding 12 months. If he is found guilty for the second time or more, he will then be sentenced to a fine between 2,000 ringgit and 10,000 ringgit. He will also be imprisoned for a term not exceeding 2 years. Similarly here, in addition to that, he may also be disqualified from holding a driving license for at least 12 months, and the court shall have the power to order a longer period of disqualification. I'm sure everyone is aware that there has been an alarming increase in the number of cases pertaining to individuals driving under the influence of alcohol. For example, in this slide, I've extracted the news that was reported by New Straits Times in May this year. In this case, the driver was drunk and he failed to slow down or stopped at a roadblock. Subsequently, he rammed his car into a police officer and caused the death of the innocent policeman. In addition to that, he was also found to be driving without a valid driving license during the MCO period. Moving on to my next slide, I've also extracted the news that was reported by New Straits Times last month. You may be aware, as part of the initiatives in curbing the increase of fatal accident cases caused by drink or drunk driving offenders, there has also been an increase in the roadblock operations, also known as Ops Mabuk. Ops Mabuk is an operation that was initiated by the Kuala Lumpur Police and has now been extended to all states in the country. In this news shared here, during the Ops Mabuk roadblock that was carried out for a mere 3 hours, a total of 11 individuals were arrested for the offence of drink driving. This is another piece that was reported by Sarawak Dayak Daily. On 4th of July, 6 individuals were stopped at the Ops Mabuk roadblock for the breath test, and results obtained by the officers in charge at the roadblock were positive for alcohol. The Padawan police have also indicated that there would be an increase in roadblock operations, mainly to curb drunk driving cases in Sarawak. Moving on, I would like to briefly share with you the case of public prosecutor against Chew Jin Jong. In this case, the person was charged under Section 44 of the Road Transport Act, which I briefly explained earlier. The driver in this case was found to be driving under the influence of alcohol. The court highlighted in this case that the effect of damage sustained by the cars, as well as the death of the deceased, clearly leads to a conclusion that the driver was undoubtedly affected by the alcohol in his system when he was driving. It was also highlighted that it is not open to a driver to say that he believes he generally has a high tolerance in alcohol and therefore he was not acting irresponsibly. In other words, while the actual level of alcohol tolerance may vary between individuals, and while most of us will probably agree that alcohol may affect the mental state of a person in different ways, it does not change the fact that the act of driving under the influence of alcohol, particularly when it is above the prescribed limit, remains in disregard of the law. Upon taking into consideration the mitigating and aggravating factors raised, the court decided that the accused person was found guilty and convicted as per the charge under Section 44 of the Road Transport Act. He was subsequently sentenced to custodial sentence of imprisonment for 42 months and a fine of 9,000 ringgit. There was also a disqualification of his driving license for a period of 5 years. While this case is currently in the process of appeal, we can see that the law has taken a rigid and uncompromising approach to drunken driving. This is undoubtedly to preserve the interests of justice and to prioritize the public interest. Now that I've discussed the offense of drink driving and its penalties, let's move on to your legal rights and obligations at a police roadblock. In gist, if you encounter a roadblock and you are instructed by the police officer to stop at the side, these are the few non-exhaustive things that you should take note of. In the event you are suspected of driving under the influence of alcohol, you will be asked to carry out a breath test. You may then ask me, is this breath test mandatory? Can you refuse to comply with the instructions given by the police officer? The quick answer to this question is no, as the breath test would be mandatory. Later on, my colleague will further explain the repercussions of such refusal. The next question would then be, what happens if you fail the breath test? Or what happens if you are instructed to go for further tests, such as a second breath test, or a urine test, or even a blood test? You may also need to know what are your legal rights in the event you are arrested at the roadblock. These are the key issues to have in mind if you are stopped at the police roadblock. Also, it is essential that you cooperate with the police officer at all times. So if the police officer is not in his uniform or he appears to be very suspicious to you, what you can do is you can always request for his identification tag, and you can take down the important information. So you can take down his name and his ID number, so you can check with the nearest police station if you think it is necessary. In this slide here, these are the frequently asked questions in relation to breath tests. So what are the circumstances that you can be compelled to carry out a breath test, or what is a breath test? Where will the breath test be carried out, or how many breath tests can you be compelled to carry out? Our associate Vivien has prepared an article on these FAQ. You can refer to it and on our website after the talk today. Should you be asked to carry out a breath test, these are the key issues to always bear in mind. It is not necessary for you to be driving at the time that you are required to take a breath test. You can be asked to carry out a breath test in the event you are attempting or suspected to have likelihood of driving under the influence of alcohol. There are two possibilities. You may be required to carry out the breath test at the roadblock itself, or you may be required to do so at the police station. However, if you are compelled to, you have complied with the breath test requirement for the first time at the roadblock, it is important to remember that any further tests can only be carried out at either the police station or the hospital. As you can see in my point number 4 here, you may be asked to carry out a maximum of 1 breath test and a subsequent second breath, blood, or urine test. So in other words, there'll be 2 tests that you may be required to undergo. Moving on, let's see what happens if you fail the breath test. Under Section 45B, particularly Sub 5 and Sub A of the Road Transport Act, it grants the police officer the power to arrest without a warrant if you fail the breath test or if the proportion of alcohol in your body exceeds the prescribed limit. I will then move on to briefly discuss or briefly explain an arrested person's right pursuant to Article 5 of the Federal Constitution. These are the 5 most important elements to always remember. You are protected under Article 5 of the Federal Constitution. So if you are arrested, you have a right to be informed of the grounds of arrest or reasons for being arrested. However, the police officer does not have to inform you of the grounds of arrest in situations where it is clear and obvious to you. For instance, if you are caught in the act, it is not necessary for the police officer to still inform you. You will also have a right to seek legal advice and be defended. The police officer has a duty to provide you with reasonable facilities for you to consult and communicate with the lawyer of your choice. You also have a right to communicate with your family or friend. Such right cannot be denied unless there are grounds to suspect or believe that such communication will lead to tampering of evidence or the safety of others will be at stake. During the investigation, you also have a right to remain silent. You particularly have a right to remain silent if you're of the view that anything you say may expose you to a criminal offense. At the end of the 24 hours of your detention period, you must be released. However, if the police officer is of the view that further detention is deemed necessary, the police officer must bring you before a magistrate to apply for an extension of the detention period. The next topic in line is the police powers after an arrest is made. My colleague Ryan will take over from here to further discuss the key issues. Thank you for listening to me, and I hope you find my session helpful. For now, I'll hand the session over to you, Ryan.
Hi, good afternoon, everybody, and thank you for your interest in participating in today's talk. So I'll be picking off where Janessa left off, and I'll be giving everybody a brief explanation on what can happen to you after you're brought back to the police station upon arrest. So before I begin my segment, I would like to emphasize that the result of the breath test taken initially at the roadblock is but a mere estimate. It is in no way conclusive. And you cannot be solely charged under that sole breath test. In other words, if the initial breath test is over the prescribed BAC limit, the police officer may have a reasonable cause to bring you back to the police station to carry out further tests to further ascertain if you are in committing an offense. To ascertain whether you are committing an offense and in requesting for more specimens for analysis, the police will be relying on the powers given to them under Section 45C1 of the Road Transport Act 1987. So among the things that can be done is that the police could require a suspect to provide 2 specimens of breath tests by means of a prescribed breath analyzer. Besides that, they can also require a suspect to provide a specimen of blood or urine for a laboratory test, notwithstanding that a breath test has been conducted. But it is important to take note that a specimen of breath under this section can only be taken at a police station and can only be conducted by a sergeant or an officer in charge of the police station. Now, in regards to a specimen of blood or urine, specimens of blood and urine are very sensitive, and there ought to be different procedures when it comes to the governing of these such specimens. So a blood and urine specimen can only be made at a police station or a hospital, nowhere else. It would be unlawful and impractical for it to be done anywhere else besides these 2 places. However, it cannot be made at a police station unless the police officer has reasonable cause to believe that for certain medical reasons, a breath specimen cannot or should not be provided. A blood or urine specimen cannot be made at a police station, also unless the prescribed breath analyzer is not available or is not practicable to be used, notwithstanding that a breath specimen has already been provided, either once or twice. This means that even though a breath specimen has been provided, you can still be required to give a specimen of blood or urine. It is important to take note that the police officer has to consider medical advice before determining whether or not a specimen of blood or urine is more appropriate to be taken. Moving on, upon arrest, I'll be touching on detention. Detention is governed by Section 45E of the Road Transport Act 1987. So once you're arrested, a suspect may be detained at a police station until it appears that the suspect would not be committing an offense under the provisions Janessa, my colleague, mentioned above. A suspect A period of detention shall not exceed 24 hours, and he cannot be detained if it appears that he was in a condition where there was no likelihood of him driving or attempting to drive. So for instance, if he was brought back to the police station and it is really apparent that there is no chance of him driving or attempting to drive the vehicle, he shall not be detained. If, as mentioned earlier, a suspect cannot be detained for over 24 hours, if the police fails to comply with this time limit, he or she must immediately bring the suspect before a magistrate without any unnecessary delay to get an extension of time. This is stipulated under Section 28(1) of the Criminal Procedure Code. The police, once at the magistrate's court, can then obtain a remand order to extend the detention beyond the stipulated 24 hours. However, it should be noted that a police officer shall in no way detain a suspect for a period longer than what is reasonable under the circumstances of the case. So for example, if it's a clear-cut case and not many complicated facts, you cannot be detained for a period longer than what is reasonable in that context. So now the question that many people will be wondering is, if I'm arrested, can I refuse to provide a specimen? Well, the answer is you can at your own risk, because if you do refuse to provide a specimen, you might be found guilty of another offence entirely. This is pursuant to Section 45C, subsection 6 of the Road Transport Act 1987. So what happens if you refuse to provide a specimen? Well, if you fail to provide a specimen without any reasonable excuse, you shall be guilty of an offence, and on conviction, you can be punished with a fine between Rm 1,000 to 6,000 and an imprisonment term not exceeding 12 months. If in the event you are caught again and you are convicted another time, the fine will be in a region of Rm 2,000 to 10,000, and the imprisonment term will be doubled up to 24 months. And you will be disqualified from holding or obtaining a driving license for a period not less than 12 months. Now, moving on, I will discuss the drink driving penalties in other jurisdictions and compare how it relates to the Malaysian penalties. I think it's important to know the penalties in different jurisdictions to know where we're at in relation to the penalties that the government has set out and how we can improve to stop drink driving and needless accidents. So the first jurisdiction that I will cover is the United Kingdom, as they have a similar law system to us. So road traffic accidents in the United Kingdom are governed by the Road Traffic Act 1988. Now, driving or attempting to drive while you're above the prescribed legal limit entails a 6 months imprisonment, an unlimited fine, and a driving ban for at least 1 year. Oh, before I forget to mention, the prescribed limit in the United Kingdom is the same as in Malaysia. On the other hand, refusing to provide a specimen entails another 6 months of imprisonment, an unlimited fine, and a driving ban for at least 1 year. From this, we can see that the penalties for these two offences are not as heavy as the Malaysian jurisdiction. But when we move on to the offence of causing death when intoxicated, we can see that in the United Kingdom, if you drive drunk and you cause death, it would be a 14 years imprisonment, an unlimited fine, and a driving ban for at least 2 years. And once you're done with that driving ban, you would have to take an extended driving test. Now, moving on to Singapore. Singapore just recently tightened up their rules in relation to drink driving in 2019. So for first-time offenders driving drunk, you might be subjected to imprisonment not more than 12 months and or a fine of 2,000 Sing dollars or 10,000 Sing dollars. And you will get a driving ban of at least 2 years. For second-time offenders, there's a mandatory imprisonment term for up to 2 years and a fine up to 20,000 Sing dollars. So it is important to note that for the difference between first-time offenders and second-time offenders is when you offend for the first time in Singapore, you might get an imprisonment term or you might get a fine. It's not both. It might be both, or it might be both, but it's not necessarily all the time both. But if you offend for a second time, it's automatically an imprisonment term and a fine. Now, in Singapore, if you cause death while intoxicated, there is an 8-year imprisonment term and an unlimited fine. Now, in the Philippines, the prescribed blood alcohol content limit is different. For non-professional drivers, it's below 0.05%. And for motorcycle and professional drivers, it's below 0.01%. What I found interesting about the Philippines prescribed blood alcohol content limit is that to test it, a breathalyzer test can't be used immediately, and it can be only used if a suspect fails 3 field sobriety tests. These 3 field sobriety tests are the eye test, the walk and turn, and the one-leg stand. So essentially what the police officer can make you do in the Philippines is at a roadblock, if they suspect you of being drunk or driving drunk, they can make you get out of the car and you would have to do these 3 tests. You might have to walk and turn, you might have to do the one-leg stand, and you might have to do an eye test. And only then, if you fail all 3, can you be asked to take a breathalyzer test. So in the Philippines, if you are convicted of drink driving for first-time offenders, it's an imprisonment term of 3 months and a Filipino pesos fine of 20,000 to 80,000. But that only equates to a total of 5,000 ringgit to 8,000 ringgit, and a driving ban for at least 1 year. And if you cause death when intoxicated in the Philippines, it's a maximum of a 500,000 Filipino pesos fine, which is an equivalent of RM 43,000 in Malaysia, and you might be penalized under the revised penal code for murder and causing death. Now I will move on to the last segment of my speech, which is the proposed amendments to the Road Transport Act 1987. Now, drink driving in Malaysia has become very, very prevalent. As you can see from this graph, in a short 5 months in 2020, we are approaching the total numbers in 2018 and 2019. This shows that it is a serious problem. It has to be tackled appropriately, and it has to be curbed, because in this short 5 months, it's ridiculous to be reaching the total figures in 2018 and 2019. As you can see from this slide, there have been numerous reported drunk driving accidents in the news, most recently on the 1st of June at the Sultan Iskandar Highway at Kuala Lumpur. Over this year, I think we've all heard a lot of cases about drink driving. Even during the MCO, people were driving into roadblocks and causing death to Grab food drivers, which is totally unacceptable. And 455 people in Kuala Lumpur have been arrested for driving under the influence of alcohol in this short 5 months. So it has become a hot topic for debate, and there have been outcries by many areas of the public calling for stricter rules, stricter penalties, even the banning of alcohol if need be. So Wee Ka Seong, our Minister of Transport, has only just yesterday tabled his first bill of amendments to the Parliament during the hearing. And he proposed that the penalty for causing death while intoxicated be increased to 15 years in jail and a fine increased up to 100,000 for first-time offenders. Now, this is a significant jump, as the initial penalty was only 20,000 ringgit and 8 to 10 year ban, 8 to 10 year jail time. And he proposed that for subsequent offenders, has to be imprisoned for a period of 20 years and fined up to RM 150,000. That is a very big jump, and that will be a good deterrent. And he also proposed to increase the driving suspension from 10 years to 20 years. Wee Ka Seong also proposed to lower the prescribed alcohol content limit down to the standards set out by the World Health Organization. So under his proposed amendments, it will be 22 micrograms of alcohol in 100 milliliters of breath. So if you are requested to take a breath test, if you're below 22 micrograms, you would be brought back to the police station. And 50 milligrams of alcohol in 100 milliliters of blood, and 67 milligrams of alcohol in 100 milliliters of urine. Now, Datuk Takiyuddin, the minister in charge of the parliament, has come out numerous times and stated that it is not the government's intention to deny non-Muslims the right to drink alcohol. Non-Muslims are free to do so as long as the relevant legal provisions are complied with, as long as no one is drunk driving, causing death, causing injuries, and causing accidents while drunk. Then there is no problem with anybody drinking. The proposed amendments are very much welcome, as the increased rate of fine and the longer jail time means that offenders can now be prosecuted in higher courts, and most namely the Sessions Court, which can in effect grant out stronger and more deterrent jail time and sentences. And Datuk Takiyuddin also discussed the possibility of having cases involving intoxication and death to be investigated under Section 302 and 307 of the Penal Code. Section 302 of the Penal Code deals with murder, and Section 307 deals with causing death. Now, I'm done with my segment of the speech. I hope that was helpful, and I'll pass the floor back to Vivien.
Thank you, Janessa and Ryan. We will now take questions that some of you have posted on Slido. Okay, the first question we have here is, if my alcohol tolerance is high and I can drive nicely, but I fail the breath test, will I still be punished? Janessa, can you take this?
Yeah, sure. The answer is yes. Even if you can still drive nicely and your alcohol tolerance is high, as explained earlier, in the event you fail the breath test, you can still be punished because it is an offense to drink and drive. You don't necessarily have to be drunk.
So you're saying that even though my alcohol tolerance is high, as long as the prescribed limit of alcohol in my blood, body, or urine is above the prescribed limit, then it is an offense, correct?
Yes.
What kind of factors do they take into consideration to determine, or rather what kind of factors that one should take into consideration to determine whether your alcohol is, the alcohol level in your body is above or below the prescribed limit?
It sometimes depends on the health of the person. It also depends on the health of the person's liver, the person's weight, the period between the time they consume food and they drink, the period of time they rested before they start driving. All these are factors to take into account when they decide whether or not they're fit to drive.
Thank you. Okay, I'll take the next one. Will I be in trouble if I'm resting in a car after drinking, but will only drive once I'm sobered up? Janessa, can you take this?
Sure. Yes, so if you are found to be resting in a car, then you may be charged under Section 45 or Section 45A of the Road Transport Act, because the police may have reasons to believe that you have control or you're in charge of the vehicle, and that itself is an offense already.
I think in addition to that, I think we can also look under the Section 48 offense. So basically, even if you stop your car at the roadside, or let's say at a highway, if you're obstructing other cars, or if there are no other reasons, even if you're not drunk, but you're just resting in your car, you stop by the side, it's still an offense because you're obstructing the traffic, or you're obstructing other cars. Yeah. Can I choose to pay a fine and not go to jail, Ryan?
Yeah. You don't have a choice, actually. It will be decided by the court based on the circumstances and facts of your accident, of the whole case. You can't choose to pay a fine and not go to jail if that's what the court decides.
Yeah, correct. So the court decides whether, I believe the section says "and," correct, right? Is it "and" or
"and"?
Yeah. But then I think the court has a discretion to issue a compound. So if the prosecution decides that they want to compound you, they can, instead of sentencing you to a fine or a jail, or rather ask for a sentence for a fine or jail to compound the offence, ask the court to compound. So if that's the case, then I think you can just pay off the compound. And if I'm not mistaken, the maximum compound is 300 ringgit. Okay, we'll take the next one. Due to the recent increase of drink driving offences, where some resulted to injury or death, will the courts be more likely to impose heavier sentences? Ryan?
Well, that is the whole purpose of having the amendments, the proposed amendments. We are certainly going in that direction, and we certainly do want to impose heavier sentences on drink driving and causing death as a deterrent to stop people from doing so. So once the amendments do kick in, I believe the courts will follow suit and impose heavier sentences.
If the new law on Road Transport Act is enforced, will it apply retrospectively to offenders whose case has not been called in court yet? Janessa, can you take this?
Yeah, sure. So if the bill is passed and the amendments already enforced at the time the accused person is found guilty and is sentenced in court, then yes, the new penalties would apply.
So you're saying that the penalties will apply on the day he is sentenced?
On the day he is sentenced, yes.
How do we confirm that the device, the law enforcement agencies, I believe, are using is calibrated accordingly to detect someone's alcohol level while driving? I think this question is asking, how can we confirm the accuracy of the breath analyzer or any other testing device? Janessa, can you take this?
Yeah, sure. So I guess if you are stopped by the police officer at a roadblock, or when you are required to carry out the necessary tests, you have to comply with it. And if you feel suspicious, or if you're of the view that it may not be the accurate device, you may request for a second test to be carried out at the police station, or if you want, you can request for a second test to be carried out at the hospital. And if the results are out and you wish to challenge the result, then that will have to be in court in the event there's a trial going on.
Can the police officer at the roadblock compel the passengers to take a breath test, or is it only for the driver? Janessa?
It will only be for the driver. So because this is drink driving or drunk driving, so the passengers will not have to go for the breath test unless you're found to you're suspected of having control, but it's very unlikely. It's always the driver.
Ryan, what happens if a Muslim drinks and drives and causes death? What would happen in that scenario?
Well, for the first part, if you are caught drinking under the Sharia criminal offences, you will be liable to a fine not exceeding 3,000 ringgit or an imprisonment for a term not exceeding 2 years. And it depends on who arrests you as well. If it's the police who arrest you, you would be charged under the penal code. If a religious officer such as Jais or Jakim arrest you at the roadblock, you'll be charged under the Sharia laws. So what happens to you then would ultimately depend on who is arresting you.
Yeah, I think that's I mean, to put it more, to distinguish the two things, is basically, I think your question is combined. So what happens if a Muslim drinks? That itself, that's a full stop there. If a Muslim drinks, it is an offence under Sharia law. And the penalty, as what Ryan has said, is 3,000 ringgit fine, correct?
Yes.
Okay, so that is one offence. And that is if the authorities, you are found drinking, right? If a Muslim is found drinking and you're caught drinking. That's one. And then if you drink and drive, there's another offence, which is under the Road Transport Act. So that one, you will be charged under criminal law, under the penal code. Sorry, not penal code, Road Transport Act. So it's two different courts, two different kind of charges, two different scenarios. So, I mean, the likelihood of you getting caught for both is when maybe two authorities come to you at the same time, and then you'll be charged for the two offences. But yeah, like Ryan said, it depends who comes to you and arrests you or bring you to the police station and things like that. So it depends. Can I obtain legal advice when they ask me to take the breath test and refuse the test until I have my legal representation? Janessa, can you take this?
Sure. So the quick answer to this is no. You are not allowed to refuse when you are asked to carry out the breath test unless you have reasonable grounds. So even if it's the first or the second test, when you're compelled to do so, you have to do it, and you will only be able to seek legal representation in the event you are arrested by the police officer after failing the test.
Not just after failing the test, I think in addition to that, it's also you can seek legal representation once you're arrested. You can ask for legal representation, but if they require you to take tests in between, you cannot refuse. You have to take it. So it is not a reason for you to delay. Logically speaking, of course, because if they allow you to delay, then technically you'll be sober by then it defeats the whole purpose. Okay. Will I be able to ask the law enforcement to show me the proof of the certification of last calibration done for that device? Janessa, can you take this?
Sorry, I didn't get a question.
Will I be able to ask the law enforcement agency to show me the proof of the certification of last calibration done for that device?
As in the test result, right?
I think this is the calibration of the device. So can you ask for the proof that it's actually accurate?
I don't think so. I don't think you can do that. You have to still comply with the test, and if you have a view that you need to go for a second test, then you can request for a second test. And again, the authenticity or the reliability of the result, it can be challenged at a later stage.
Yeah, so I think to challenge the device, the defective device, it is something to be done in court later during trial as a defense to say it's not that I was drink driving, it's just that device was defective. And on top of that, so what Janessa said just now was that if you think that the device is defective, ask for a second test, demand for a second test. Because, I mean, it really depends. Like, at the moment, do you look really sober or do you look really drunk? So that's number one. Number two, if you're borderline, if the results is borderline, you can ask for a second test and you say, look, your device is not accurate. And if they refuse, this is another ground to bring in during at trial later in court to say, I challenged it during the requirement to give the test. I wasn't given a chance. And now I'm disputing the accuracy of that device, the breath analyzer. And then it's for them to prove, it's for prosecution to prove that the device was accurate and things like that. Yeah. I think this one we've answered. So we'll go to the next one. Will Section 45A be amended, right?
Yes, that is the proposal right now to amend Section 45A.
What happens if a Muslim is driving his or her intoxicated non-Muslim friend home and got stopped at a roadblock?
Well, I think this can be answered by Janessa's answer earlier. If it's called drink driving, so the only person that will be tested will be the driver. And if you do not drink and you're just driving your non-Muslim friend home and there's no blood alcohol content in your body, there's nothing to worry about.
Yeah, correct. So there's nothing to worry about because bear in mind these three offences are, just to wrap it up, it's basically Section 44, Section 45, Section 45A. So 45A only came later, I think in 1944, around that time. So what happened is that it used to be an offence only two things. One, you caused injury or you caused death while driving with alcohol content in your body. That's Section 44. And then Section 45 is unable to drive because of alcohol, but you drive, then that is an offence. Then Section 45A comes in to say, look, it's not only if you're driving, it's not only if you cause death or injury, but it's also when you're in charge of a motor vehicle, when you have alcohol content in your body, which is above the prescribed limit, or if you're attempting to drive, or if you're driving with alcohol content above the prescribed limit. So I think before this, the prescribed limit was only used as a guide, but now it is used as long as it's above the prescribed limit, then there's no other reason to say, no, I wasn't drunk, or I was fit to drive, I was able to drive. So the laws are getting stricter, as you can see, and so yeah, I think that's the message we're trying to get across. Another message we're trying to get across is to comply with the law, to comply with police requests, especially at roadblocks, because you have heard people driving off at police roadblocks, refusing to take breath tests. All these are offences, and you don't want to commit double offences at the same time, because I mean, they have your what do you call it, your car plate number and things like that. It's easy to find out where you stay and then arrest you and things like that. You don't want to come to that point. Yeah. Janessa and Ryan, do you have anything to add?
Yeah, I think I have something to add in regards to the prescribed limits, the blood alcohol content. It's an umbrella. I think it's sort of like an umbrella. You either go past it or you don't. So if you go past it, you are guilty of an offense. If you're not past it, you're not guilty of an offense. I think it's as simple as that.
Yeah. And also, another point to add, I just remembered, is that if let's say you go to, so we go, imagine a situation where, let's say you drank alcohol and the alcohol content in your body is above the prescribed limit. Okay, so you drive, you reach a police roadblock, you're asked to take a breath test. Okay, so you take the breath test because you have no choice, you have to take the breath test. After you take the breath test, it reaches a certain limit, and then it's either they will issue a notice on the spot to attend court, or they will ask you to go to a police station right away, a nearby police station. Okay, then once you reach a police station, they can either detain you or they can bring you to the court, depending on the time, of course, and then bring you to the court, arrest, charge you, read the charge to you, then you plead guilty, and then you'll either be issued a fine and sentence or a compound. So, and then what happens after that? What happens to your license? What happens to your merit points? So all these things, once you're charged, once you're convicted, it will be notified to the register of drivers in Malaysia, and you will be awarded demerit points. And bear in mind, if your demerit points exceed 20, then your license will be suspended. So that is one point to note. And if your license is suspended and you continue driving, that is also an offense. So take note of all these things. To wrap it up, if you have any other questions, feel free to call us for free legal consultation, 30 minutes. And we look forward to meeting you in our future talks. Before that, don't leave yet. I have something to add. These are the following talks at the upcoming weeks. On the 23rd of August, our firm's Senior Associate John Chan will be giving a talk on fixed-term employment contracts and whether foreigners can be employed on a permanent basis. On the 26th of August, our partner, Christine To and Associate Sue-Ann, will talk about performance bonds, followed by 9th September on partnership dissolution and distribution of partnership assets. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. If you have any other questions which we did not manage to answer earlier, please fill it in our feedback form and we'll get back to you as soon as we can. We really appreciate your comments so that we can continue to improve our online talks in the future. Thirdly, please do follow or like our social media accounts. Fourthly, if you would like to speak to our lawyers, we offer a complimentary 30-minute consultation, as mentioned just now. You can fill in the form on our website, and the link is also posted in the chat. Lastly, thank you for joining us. We hope you have found today's session informative and useful.